afternoon, everybody. My name is Abhigya Ori, and I am an assistant professor in the Faculty of Law and Governance at Jyoti Vidyapeeth University, Jaipur. So, today, what we'll cover is the sources of international law. So, now, law has always been prevalent, has always existed, but since we've derived law in a written form, or we can say in a codified form and in an enforceable form, we somehow got an urge to learn where this law actually came from. So every law in its particularity has some or the other source or a point of origin. Similarly, goes for the international law, also has a point of origin, but we somehow feel that law does not origin from one single point. We cannot derive law from one single point. There are a lot of sources that come together and form one particular law. Especially the international law, because it has to be applied internationally, has to be more inclusive, has to be more adaptive. So there has to be a lot of sources for the international law. Now, the sources of international law are, we can say, formally recognized or legally recognized in Article 38(1) of the International Court of Justice. This is the article that talks about the sources of the international law, and this article gives 4 sources as the main sources of international law. There are different sources, there are also other sources, but these are the 4 main sources that Article 38(1) of International Court of Justice has given for the international law. These, we can say, are the primary sources. These are also known as the primary sources of the international law. So the first one that we'll talk about is the most basic, and what international law is basically known for, the treaties and the conventions. Treaties are we can say a contract or a legal drafting between 2 countries. Now initially it started with countries, but now these can be between 2 countries or between 2 international organizations or between a country and an international organization. So wherever there are treaties and conventions on a particular topic, the law made internationally will always keep both of them in mind, and hence they are the best and the most reliable source of international law. Also, they are the most modern source of international law. So the first is treaties and conventions. The second is customs. Now we have to adapt the entire world in one particular legal system, that is the international law. So we will keep in mind some things that have already been going on for some countries. Like for some indigenous countries, we have to make law. We have to first see how the indigenous countries have been working till now. So we look at the customs of those indigenous countries. Now the customs, there can be a lot of customs. There can be many customs and many various customs. So we see the customs that are the most inclusive, we adapt them in the international law. Also most prevalent, that is, have been going on for a long period of time. You cannot say we've been doing this thing for the past 10 years and hence it's a custom. No, it has to be something that has been going on for generations to come, and almost from time immemorial, before people remember. Now, if something is so prevalent in a society and has the backing of logic, only then can it become custom for the source of international law. It can be a custom otherwise, but if it has to be a source of international law, it has to be going on for some period of time. The third is general principles of law. Now, when we form the international law, we do not forget about the general principles of law that are basically imbibed in our law. For example, natural justice. Any law that we make, domestic, municipal or international, has to follow the rules of natural justice. Okay, human rights. The entire human rights part is basically based on the natural justice system or the rule of law. Like for example, Audi Altrum Patra. This is a basic law that has to be followed by everybody. Now the fourth and one of the very most important sources of international law is judicial decisions and teachings. Whatever the ICJ in any judicial pronouncement has said becomes the ratio decidendi and the obiter dicta, and the ratio decidendi and the obiter dicta of any case law is in itself a very important source of law. इसको use करके we can make acts, conventions, guidelines, or any formal thing that is enforceable and applicable worldwide, and hence becomes one of the most important source of international law. Thank you so much.